Now, Jayant Sinha.
Mr. Jayant, sir, when I get a chance, I'll answer the honourable member's question as well. I'll keep my comments short. I recognize it's late in the evening. Members are tired.
As brief as possible.
Minister has spoken already at length, so I'll keep this very short. I first of all want to very quickly thank everybody that's worked for many years in putting this legislation together. I want to thank the members in the Lok Sabha that passed it, but in particular, I really do want to thank the Joint Select Committee that worked on it. There were 30 members, 10 from this August House that have improved upon this in very significant ways, including the fact that they've strengthened workmen's rights, they've introduced cross-border insolvency recourse so that we can go after cross-border insolvencies as well, and they have introduced and strengthened the role of the operational creditors as well. So we owe a lot to the Joint Committee, and I really want to recognize them for the work that they've done. Many members spoke today, and I want to thank them for their contributions as well. What I'll try and do is to, in a very short, pointed way, answer the specific questions that were brought up. First, I want to start with my good friend, Professor Gowda, and I want to remind him, since he was at the University of Pennsylvania, that the economist that he refers to was at Harvard, Joseph Hare, Professor Joseph Schumpeter, who obviously spoke about creative destruction. And I think all honourable members, maybe there may be a few exceptions here, but I think all honourable members will agree that we operate in a market economy. And because we operate in a market economy in this country and around the world, and because progressively over the last 25 years, we've moved more and more towards an open market economy where we brought down entry barriers, as Professor Gowda exactly correctly said, we also have to make it possible for exit, resolution, revival to happen in a smooth, effective, efficient manner, protecting the various stakeholders. And that's what could not be possible in the Indian economy previously, and that's what this quite historic legislation will enable us to do. We have many debates in this House and the other House as well. We have many discussions. But I just want to pause for a second to remind us that this is historic legislation. We are changing the Indian economy because we are enabling it, in fact, to be able to let the processes of creative destruction that Professor Gowda was speaking about operate much more efficiently. And we will do that while protecting the people who matter. And the people who matter most, as Tapanda correctly said, is obviously the workmen. And we have to make sure that those stakeholders, because they are the most vulnerable, are protected first. And he brought up several instances where people have not got their dues paid. In some cases, it was 43 months and so on. And the way, Tapanda, this law is set up precisely avoids those problems because it enables workmen to initiate the insolvency process. So, for example, if it's been 3 months or 6 months that you've not been paid, you can initiate the insolvency process and you will be first in line for up to 24 months. So the cases that you're worried about, those are precisely the kinds of cases that we will avoid through this legislation in the way that it's written. And so your fears, I think, will be set at rest when you understand exactly how this law will work. Those historical cases in most instances, if they are already being tried by a superior court, for example, the high courts or the Supreme Courts, we cannot initiate this process for them. But if they are in some of the other courts, then it is possible in a voluntary basis to bring them to the NCLT and see whether we can have a more efficient resolution process. But we wanted to protect the most vulnerable, and I really want to thank the Joint Committee for ensuring that it was 24 months worth of workmen dues that we protect in this manner. Of course, we as a government are trying our level best as well to create a robust safety net so that it's not necessary that our workers are reliant only on a company or a job, because as Professor Gowda points out, that in a market economy, companies come and companies go. And if in India we rely only on the company for a safety net, we are making many of our workers very, very insecure and vulnerable, and we want to avoid that through some of the other initiatives that we are doing in the government. But for an existing company, of course you can do it. But what if a company is already in a high court proceeding, which is the case that Tapanda brought up?
I'm sorry to interrupt, my friend. In case there is a company which has been lying sick for a number of years, and workmen are still struggling to get their dues, creditors are still struggling, and on the day that this act is notified, the conditions for petitioning or invoking the jurisdiction of this act are made out, even though it's a pre-existing state of sickness, the board, the forum will have jurisdiction even with regard to those. So the assets can be sold unless something had already been wound up.
Tapanda and Professor Gowda also wanted to understand how revival will work within this framework. Well, when a company is put into bankruptcy, there is also an ability to preemptively talk about bankruptcy. So the revival process can actually start even before you go into bankruptcy. And obviously, you know what the shadow of bankruptcy will do. So the idea would be that the stakeholders, understanding that bankruptcy is possible and it's a costly, time-consuming affair, will preemptively sit down and negotiate and come to a better settlement. That's indeed possible. But if you do go into bankruptcy, or if you do it preemptively, there are three possibilities that are worth considering when you go into a revival process. One is you find that it is the promoter that is not capable of managing that company any longer. So you replace the promoter because the secured creditors, workmen, and so on have preemptive rights over the promoter, the equity holder at that point. So you just replace them, the company is viable, it operates, it's competitive, and it moves on. The second case is if the company is actually requires a complete resetting of its costs and its capital structure to become competitive, there's a restructuring process that's required, and that will be done through the insolvency process. There's a reset, and then after the reset, the company is competitive once again, and it goes forward and is successful. That is what happens consistently in the United States. They go into bankruptcy, their liabilities are reset, they become competitive again, and then thereafter they do fine. There is a third case where, in fact, you have to go into liquidation because the company cannot compete any longer. I myself, in the United States, in some of the work I've done, have taken companies through either a revival process or a liquidation process. But if we have an effective resolution process, we can actually do that quite well. So again, this legislation will enable us to do this kind of revival depending on which case you want to put it through, and that depends on the company's competitive position. So we will be able to do that in a much more seamless way. Shri Naresh Agarwal ji wanted to know how the courts will actually work, how the appellate process will work. Very quickly, I want to tell him that we will have the National Company Law Tribunal. The appellate body to that is the NCLAT, and that can then be appealed to the Supreme Court. In the case of individuals and partnerships, you go to the DRT, as Honorable Finance Minister just said, then you go to the appellate body, the DRAT, and then again to the Supreme Court. That's how it will work. There was a question also about PSUs. PSUs are companies as well, and of course they have in some ways the sovereign backstopping them, so if the sovereign steps in, it's a different matter. But because they are companies, they are subject to the same laws that we would be bringing in as far as bankruptcy is concerned. Vivek Gupta ji wanted to understand whether bankruptcy would be possible in a repeated way. I don't think that will be possible because once you go through bankruptcy, we capture that information, and then there will be few creditors who will want to give you loans again. And therefore, you will not be able to repeatedly go through bankruptcy because the creditors will not be there. So that's the way we would answer that question. Anand Sharma ji and Professor Gowda wanted to know about fraud that's committed during the insolvency process. There are some penalties. There are specific clauses that ensure penalties if you're doing fraudulent or avoidance actions. And there is a way for the insolvency manager to prevent avoidance actions. So if somebody wants to siphon assets away, those can be prevented and brought back into the insolvency process. So those clauses are in fact there. Then there were several questions about how will this be implemented, how will this actually be executed. We have limited judicial capacity, we need more judges, we need more courts. How will the industry be created, where will the professionals come from, and so on. Those are very good questions. Of course, we are working on all of those. We are setting up the courts. I'm sure Professor Gowda in his work at IIM Bangalore and other premier management institutes will ensure that this training and the coursework is put together for bankruptcy. And I will rely on him to encourage his other academic colleagues to do that. But we will, of course, go through a staged notification process implementing this as and when we find that the implementation and the execution capacity is there. That's our responsibility, and we'll certainly do it that way. To the best of my knowledge, I think the performance bonds case issue that you brought up has in fact been amended by the Joint Select Committee, so that's not something you need to worry about. And in your question also, Professor Gowda, about whether the time is sufficient or not, I want to once again remind you that it's possible to actually preemptively start talking about bankruptcy and therefore have more time rather than just the 180 to 90 days. These were the major questions, honorable members, that were brought up. No, accountability on the bankers is there through their boards, through their management structures, through their shareholders. And obviously there are grievance redressal mechanisms that are also there. And so the banks are going to be there. And with this,
thank
I
you.
commend the legislation.